Welcome to This Explainer. Today, we're unpacking over 40 years of source material to reveal the evolving blueprint of India's environmental legislation. We're going to look closely at the actual policies and data to really understand how an entire nation goes about building a legal fortress around its natural resources. Let's get right into it.
So, how exactly does a nation protect its environment in law? It's the core question that actually drove India to shift from just reactive conservation to proactive, highly specialized resource management. And as we'll see from the source texts, this kind of massive shift, it absolutely does not happen overnight. It takes building a legislative architecture piece by piece, responding to real crises, and constantly adapting to modern industrial challenges. We're covering a massive span of time today, transforming what looks like a dense chronological list into a clear, fascinating narrative of environmental survival. We're starting way back in 1972 with the protection of wildlife, moving through the sweeping powers of the 1986 Environment Protection Act, all the way to the creation of specialized courts in 2010, and finally capping it off with a comprehensive waste management overhaul in 2016. So here is our roadmap for today. 1. The foundation of protection. 2. The umbrella and the court. 3. Balancing conservation and rights. 4. Coastal and wetland management. And 5. The 2016 waste revolution. All right, Section 1, the foundation of protection. Now notice the stark contrast between the 1972 and 1980 frameworks here. Back in 1972, with the Wildlife Protection Act, forests and wildlife were actually a state subject in India. That meant the central parliament literally had to jump through special constitutional hoops just to pass a law on it. But fast forward to the Forest Conservation Act of 1980, and we see a much, much stricter central mandate. This law expressly demanded prior permission from authorities before any forest land could be diverted for non-forest purposes. Things like agriculture or construction. It was an absolutely vital step to just hit the brakes on rapid deforestation. Laying this foundation also meant tackling industrial pollution head-on, which brings us to the Water Act of 1974 and the Air Act of 1981. These acts were a real game changer because they established the central and state pollution control boards. Now, at first, enforcement was mostly handled through criminal prosecutions, but a massive shift happened with a 1988 amendment. This update finally gave these boards the teeth they needed. It empowered them to inspect facilities, collect samples, and aggressively shut down non-compliant industrial plants directly. No messing around. So the crucial takeaway here is that the bold 1986 Umbrella Act isn't just some standard policy. Its mandate to handle hazardous substances is rooted directly in the fundamental duties of the Indian Constitution itself. The Environment Protection Act of 1986 was a really bold measure. It empowered the central government to take all appropriate steps to prevent pollution and to establish effective machinery to actively protect the quality of the environment. Moving on to Section 2, the umbrella and the court. Look at this structure. The 2002 Biological Diversity Act, which was actually born from a 1992 UN convention, uses a strict three-tier setup to regulate resources right down to the local level. So instead of just a standard top-down approach, this law ensures the equitable sharing of biological resources. How? By distributing authority from the national level down to the states and then directly into the hands of local biodiversity management committees. It's a really smart way to manage things locally. And to actually enforce these rapidly expanding laws, India did something incredible. They became only the third country in the world, right behind New Zealand and Australia, to establish a dedicated, fully fledged Green Tribunal. I mean, think about that for a second. Out of the entire globe, India was a true pioneer in creating a specialized adjudicatory forum just for the environment. That specialized National Green Tribunal, or NGT, was established in 2010. And it is mandated to fast-track environmental dispute resolutions. In fact, it must dispose of cases within exactly 6 months of an appeal. 6 months. By dedicating a specific court system solely to natural resources, the NGT completely bypasses those heavily backlogged traditional courts. This gave a massive, massive boost to the enforcement of sustainable development measures across the country. Which brings us to Section 3, balancing conservation and rights. Because, let's face it, conservation can't happen in a vacuum. For decades, forest dwellers have been deprived of their rights to the very land they cultivated and the common property resources they completely relied on. But the 2006 Forest Rights Act changed all of that. It provided actual restitution, proving that true conservation must protect both the environment and the traditional rights of the people who call it home. It effectively integrated the livelihoods of these communities directly into the broader conservation strategy.
Similarly, blending human benefit with the environment, we have the 2015 Green Highways Policy. This mandates that 1% of all highway project costs, which is around 1,000 crore rupees a year by the way, is strictly dedicated to planting trees. And this generates 500,000 rural jobs. Not only do these trees act as a natural sink for air pollution and dust, but the policy specifically mandates community involvement by hiring local people, NGOs, and panchayats to plant and maintain these green corridors. Environmental protection literally becomes a direct economic driver for rural areas. It's a win-win.
All right, let's head into Section 4, Coastal and Wetland Management. Notice how the 2017 wetlands rules decentralized power back to the states for wise local use. Meanwhile, the 2011 coastal and island rules drew highly specific boundaries around thriving marine biodiversity hotspots. Take the Andaman and Nicobar Islands, for instance, they're 85% forest, or Lakshadweep, which is a coral island. Their geographical areas are actually so small that the standard 500-meter coastal regulation zone just overlapped itself. So to fix that, they created a highly specific island protection zone notification. At the same time, the wetlands rules stepped in to completely ban solid waste dumping and the discharge of untreated industrial waste into these super-sensitive ecosystems.
And that leads us to our final chapter, Section 5, the 2016 Waste Revolution. Now, before you can mandate scientific disposal at treatment facilities, you have to strictly define the danger itself, right? And that's exactly what the 2016 hazardous waste rules accomplish. Whether we're talking about petroleum refining, pharmaceuticals, or paint production, this strict classification ensures that dangerous industrial byproducts absolutely must go to captive treatment facilities or common storage disposal sites. This is absolutely crucial for mitigating the adverse impact on human health. These 2016 rules dictate daily life and massive industries alike. Households now have to separate garbage into 3 specific streams: biodegradable, non-biodegradable, and domestic hazardous. But what if you're a massive construction company? Well, if you produce over 20 tons of rubble a day, you can't just toss it, no way. You have to submit a waste management plan and segregate concrete, soil, steel, and wood. And for major hospitals seeing over 1,000 patients a month, biomedical waste must be meticulously sorted into 10 different categories and packed into 5 specific color-coded bags just to prevent contamination. It's incredibly thorough. Now, a core innovation of these rules applies to electronic waste. It's called Extended Producer Responsibility, or EPR. This framework forces the companies that actually make your devices to fund and manage the collection mechanisms when those devices eventually die. It's no longer just the consumer's problem. Manufacturers and dealers are now required to set up collection points or take-back systems, which ensures that our old electronics stay out of landfills and flow right into proper recycling centers. Finally, looking at these rapid-fire plastic and e-waste updates, you can really see how the rules stretch out into rural areas, hold public event organizers accountable, and ultimately enforce a massive ban on single-use plastics. For example, by increasing plastic bag thickness from 40 to 50 microns, it actually makes them much easier to collect and recycle. The 2016 rules also acknowledge that plastic waste isn't just an urban problem anymore, formally handing implementation responsibilities over to rural Gram Planchets. And perhaps most significantly, this amendment laid the real groundwork for prohibiting identified, highly littered single-use plastic items, a ban that officially went into full effect on July 1st, 2022. So we've traced this incredible legal blueprint from 1972 right up to today, watching it evolve from simple wildlife conservation into highly technical decentralized waste management. The structure is undoubtedly there on paper, but as everyday citizens, as businesses and event organizers who all contribute to this ecosystem, we have to leave you with this final critical thought to ponder. The laws are written, but are we actually following them? Thanks so much for joining this explainer. We'll see you next time.